Good morning, Counsel.
Good morning, Mr. Chief Justice. Good morning, Justices of the Supreme Judicial Court. May it please the Court, my name is Dereji Demisay, and I represent the petitioner, John Doe, in this matter. We're before the Court seeking a review of the decision of the trial court of the Superior Court and seeking a reversal of the order directing John Doe to provide a palm impression to the Boston police under the threat of use of force by the police to accomplish the order.
One of your arguments is that if the grand jury never returns an indictment, then your client has been prejudiced unfairly. What about, is he in any different position than a defendant whose prints are taken by are obtained for the grand jury, by the grand jury, and then the defendant goes to trial and he's acquitted? Why is we don't give that defendant an opportunity to contest the taking of the fingerprints until after trial? Now, why is your client in any different position than the defendant who's acquitted after trial?
Let me answer that in two ways. Number one, they may not be that different. They will be different if we wouldn't know at this point. But for the purpose of determining whether the petitioner should have a right to review or not, the court order authorizing the use of force to accomplish the taking of the fingerprint would not matter whether or not that individual would end up being acquitted or convicted. At this point, the issue is, does this individual, subject of such an order, has a right to challenge the validity of the order before incurring the stigma, before incurring the seizure authorized by the court, and whether that seizure is supported by the requisite finding of probable cause.
But he did have an avenue to challenge it. I take it he filed a motion to quash, and the judge had a hearing and concluded that there was a sufficient basis, doesn't need to be much, but there was a sufficient basis in what the grand jury was, to support what the grand jury was seeking. Why isn't that enough at this stage?
I represented the petitioner before the Superior Court, and essentially the hearing was to look at, the judge took a look at the petition, the request by the grand jury, and made a ruling based on that.
Yeah. Well, what else would an appellate court do? They would presumably look at what the grand jury had asked for and the basis for what the grand jury had asked for, and that would be it. So
the question is, now where this individual seeks to challenge whether the information contained in the request of the grand jury was sufficient or not.
Well, he's had one challenge. He's been able to challenge it presumably before the judge.
Before the Superior Court judge.
And if he is indicted or charged, he certainly can challenge the use of that palm print against him.
Assuming that he is indicted, then that would foreclose, I believe, the argument of the use of palm print. He would be arrested.
The argument would still be that it was obtained without the proper basis and therefore should not be used in evidence. Ordinarily, that would be a perfectly adequate remedy.
Usually that kind of argument would come up in the context of the police conducting a search or a seizure and obtaining information from that.
No. I think maybe I'm wrong about this, but I take it at the trial you'd file a motion to suppress saying that the fingerprints were wrongly taken, and if you lost, you could attempt to appeal that on an interlocutory basis under Rule 15, I would think.
So here's the issue. Theoretically, a person can challenge the introduction of evidence at the trial, they would not be able to challenge the mechanics of being taken into custody or being seized, and the actual seizure that resulted from the trial court's order and the providing of the palm print.
But if in fact the order, I take it, the police are permitted to use reasonable force to enforce court orders, and when they conduct searches, they usually use whatever reasonable force is necessary to complete the search. And those things are also either challenged in the criminal process if there's an indictment, or one could bring a civil action claiming that one's civil rights were violated by the manner in which the police obtained the fingerprints or obtained the evidence at the home. And those are two different remedies.
Again, when a court authorizes a seizure, we usually require probable cause. And when a court authorizes production of, for example, as in one case, the Colleran case, that involved forced medication or some type of action that infringed on the person's liberty, there has to be showing of probable cause to support that finding and support that decision.
Okay, okay, go ahead.
The person subject to that order would then have a right, some type of right to appeal and get redress.
No, well, no. The search warrant. Okay, it's issued on the basis of probable cause. They come and search your client's home. You don't really have a right to challenge that until such time as there might be a trial, and you could move to suppress, or you could bring a civil action. But you can't file a motion in court saying, well, maybe you can, stop the search. But I don't know how you would get an appellate right out of that. You might be able to file a motion in trial court, but
now there's a distinction between a clerk magistrate based on an affidavit provided to him by an affiant, a police officer, issuing a search warrant based on probable cause, and the power of the grand jury to compel individuals to provide information in violation or contrary to the person's right to against self-incrimination, or to appear for to provide fingerprinting under the threat of force and contrary to the liberty interest of that individual. And the court has consistently said that the power of the grand jury to do that is balanced against the constitutional right of the individual. So we are in slightly different territory from the trial court issuing orders authorizing a search or seizure based upon probable cause presented to it. We have a grand jury assembled to investigate a crime, and they do have broad powers, but the court has consistently said that that power is balanced against the liberty and constitutional rights of citizens. In this case, what we challenged was the validity of that order premised upon the grand jury's request to see if, in fact, the basis given for the production of the palm prints comports with the established requisite requirement of reasonable suspicion.
Sorry. So if the order had not had the reasonable force, you'd be in the same position as the fingerprint one, right, if that was taken out. And so then you could refuse.
That's correct.
And then there would be a contempt.
That's correct.
And that's really what you're...
And then the person would appeal.
You're not looking for a new category. You're saying there is one, there's contempt, and this is different enough.
That's correct.
It takes us out of that. It's an unindicted, uncharged individual against whom reasonable force is going to be used to obtain not something in his closet, but something from his body.
Which necessarily would include a seizure by the police. So
requiring probable cause.
and I was going to get there. Essentially, Mr. Doe in this case falls under a very narrow exception of group of people who, when they're subject to reasonable force, cannot obtain redress that would be available to a whole host of other individuals who would not be subject to the threat of force.
Without probable cause.
Without probable cause. In fact, Mr. Doe, every person has a right to a review eventually by refusing to comply, incurring a contempt order, and then appealing from that contempt order.
And so
Under
when
Rule
it
15.
gets appealed, and let's say you lose, then would it be all right for them to use probable cause? I mean, to use force? Or there would just be no right to refuse?
Once the person gets the review and there's probable cause, then they have to comply. And
So
if
you
they
wouldn't
don't
need
comply,
probable, I mean, you wouldn't need probable cause.
that's
Reasonable
right.
basis
It was
or whatever.
reasonable basis.
And they have to
However,
comply, and what if they didn't comply? Then what happens?
Then they have to, the police, then the court authorized already use reasonable force. And my argument here is that whenever there is a reasonable force authorization, there has to be a finding of probable cause as opposed to reasonable suspicion. The court has not addressed that issue previously. In one case, it sort of touched on it and said, that's not before us, so we're not addressing it. But in this case, I'm arguing that authorization of reasonable force necessarily includes seizure of the person. And a seizure of the person cannot be authorized without probable cause, just
Well,
based
but
on reasonable
it's a
suspicion.
temporary seizure. It actually could be done at your home. I mean, it's not like an arrest.
It is an
It's more like a temporary investigative seizure, specifically for the purpose of gathering one specific item, which can be very easily gathered.
I would disagree with that, Justice Cody. When a person refuses to comply, to incur contempt, and the police are authorized to use force to enforce compliance, that usually necessarily the taking of the palm print at the Boston Police Department would be preceded by a seizure.
May I ask you, do you see is there a big difference between taking a palm print and, say, taking a blood sample?
The Commonwealth would say yes. I would say that it's from the individual point of view, they're both intrusive. They're both a result of an overbearing governmental action, compulsion to provide something that belongs to the individual. The Commonwealth argument is that palm prints can be left in various places, and as opposed to blood, I guess blood samples can be also obtained from different areas. However, like hospitals or other places where a person visits.
But I mean, from the perspective of to obtain the blood sample in the same way to obtain the palm print, the inconvenience is very brief. It's not something that will have a long-term effect on the accused. It could be accomplished in a matter of seconds, couldn't it?
I wouldn't say seconds. I would say that the process would begin from the individual being taken from wherever that individual is to the location where the process would be completed. And obviously, if that individual is in a position to not comply because he wants to assert his right to appeal, then that individual would be arrested and then transported where the fingerprint or palm print would be taken.
As with the blood
That's correct.
supply.
Yes. And also, the other argument that I'm making, Your Honor, is that if the Rule 15b has been held to apply to circumstances such as this, and the controlling factor has always been finality of the order.
Is that, you mean in the Levine case?
In the Levine case. And the finality and lack of any available means of available redress and those factors are satisfied in this case, and also the court has jurisdiction under 211 Section 3 under its supervisory powers as well to hear the case. I didn't get to my last argument, and I'll rest on that on my brief on that.
Thank you,
Thank you,
Counsel.
Counsel.
Thank you.
Morning,
Morning,
Mr.
Mr. Chief Justice Ireland, members of the court, John Zanini for the Commonwealth. I don't think the target of a grand jury order, even one that allows for reasonable force, is entitled to full bench review prior to the execution of the order. The Williams case, which is cited in the brief, 439 Mass 678.
I wanted to ask you, what was, I got your 16L letter. What was in Williams? Because I didn't get you.
Williams was a DNA case where they actually took, I believe it was a blood sample in that case, and the
But
court...
from a grand jury order?
I believe it was yes, it was a grand jury order, and then the court reviewed it subsequent to the trial. And the court laid out a process in Williams and said you need a verified petition, something under oath, either an affidavit of the prosecutor or a member of the grand jury, or the submission of grand jury testimony. We know from the record we had that here. You need the judge is supposed to hold a hearing, and this is for the extraction of a blood sample. The judge has to hold a hearing and believe there's reasonable basis that will significantly aid the grand jury investigation.
Didn't Levine require probable cause? No.
Levine did, because there was no grand jury proceeding, and it was treated as a search warrant. So if you get a search warrant, same thing. You need the affidavit under oath, and you go and take the evidence. I think Levine is really an outlier. There was a concern, probably 1994, for the intrusiveness of the taking of blood for DNA. Subsequently, 1998, this court described DNA extraction as a minimal intrusion. Also, Levine, there's no discussion anywhere in Levine of alternate remedies, such as just simply going back to the judge. If the person's not indicted, they can go back to the judge and file a motion and say, can you return all my blood to me? Can you return my fingerprints? Can you expunge those records from the police department? And the court can issue that order. Certainly they can file a motion to suppress if there's an indictment. So under the Williams case, the judge here really went through and followed the Williams case. And we do this in dozens of cases, DNA cases, fingerprint cases, where we go and sort of follow this script at the grand jury, and the court lays it out. I'm not sure that it really applies to fingerprints, because that's so minimally intrusive, as opposed to a DNA sample, which is somewhat slightly more intrusive, a little bit more private than your fingerprints, which are out there all the time everywhere. And we may be going overboard in terms of the rights that we're according to folks, and the hearing they're getting may be entirely unnecessary.
What is reasonable force? Let's assume that an individual gets this order and is basically told, come to the police station so we can take prints, and he says, I'm not coming. So they go to his house, and he says, I'm not going to give you my hand to do it. What is the amount of reasonable force that's appropriate?
Well, I think you have to look at two things. First, if you look at the record in this case, and you look at the docket in this case, it's quite clear that nobody went and arrested him. Nobody dragged him in off the street. Nobody took him out of his house. Nobody treated this as an arrest warrant. He was challenged in it by a motion to quash, and then an appeal to the single justice, and all these processes. And at some point, about 5 months, 6 months after that started, the Commonwealth filed a motion to compel, which was allowed and then stayed. And so now the poor grand jury order has been out there for about 10 months, while all of the witnesses' memories fade, the evidence gets stale, all of these delays are occurring. I would also point out, in the context of reasonable force, which is always left to the executive to discern and to ascertain, because the circumstances vary from case to case, which is explicitly discussed in the Williams case, where they said you can use the reasonable force necessary to take that DNA, that you have to leave that to the executive. And in the Garner case, which is a search warrant execution case, the use of a stun grenade was held to be, in the context of that case, where people inside the apartment could be armed, could be reasonable force. So the sort of the answer to the reasonable force question is the executive has to make that decision, and then after the fact, we all adjudicate, the courts adjudicate reasonable force, either in the context of a motion to suppress, a motion for the return of property, or maybe a civil rights action, some kind of tort claim. But in this case, there's certainly no one claiming that there's any unreasonable force. I don't think it's unreasonable if the person clenched their fists to sort of say, unclench your fist so we can get your palm print and your fingerprints to see if it's on the magazine of this firearm.
You mentioned the process in this case. I'm a little curious about how it came to play itself out that way. There's a request from the grand jury. There's then an order issued by a judge ordering the defendant or the individual to submit to these prints and directing the police to use reasonable force. I take it couldn't the police have just gone out and served this and then proceeded to use reasonable force? I mean, why was this treated as a subpoena? Curiosity.
I don't know. I think the police could have done exactly what you intimate. They could have, reading the order, the second paragraph of the order says use the minimal force necessary to actually get the print. The fourth paragraph says use the reasonable force to carry out the order. I think the judge authorized them. If need be, if Mr. John Doe showed up outside the police station and then refused to come in, I think they could have gone out and escorted him in. I mean, every search warrant and every court order to show up and produce physical evidence always involves an intrusion and always involves some seizure.
No, I understand that, but how, here he was able to challenge this by bringing a motion to quash, and a judge then reviewed, maybe it was the same judge that issued the order, I don't know, went back and reviewed what had been filed by the grand jury and concluded that was a sufficient basis under our case law, and affirmed or confirmed the order. Is that the way it ordinarily happens? I mean, is it?
So far, the police have not sort of treated these orders as effectively authorizing the seizure of a person. And there were actually two different orders here. So if you look at the docket, there were two different targets. Effectively, one of them complied, the other one didn't, and rather than go out and seize the person, there was a motion to quash and all the subsequent hearings.
So when you say one complied, again, the mechanics, was this order served on both, and one of them said, sure, no problem, and the other said, I want my lawyer to file a motion to quash?
Right, I wasn't at these hearings, but one of them had an attorney, and if you look at, there's an impounded docket, and on page 2 of the Commonwealth's impounded appendix, which is all the unredacted documents, there was an attorney who came in with that particular person, and he subsequently, my understanding from what I was told by the folks at the grand jury, he then, after litigating this at that level, just having a hearing with that judge, he voluntarily complied. John Doe did not voluntarily comply and has litigated this for the past 6, 7, 8 months. And really it's just an abundance of caution that the police did not go out and say, well, we're going to take him into custody and bring him in and take his prints.
Well, should we say something about that? I mean, should we say if the court's going to issue an order authorizing force to secure fingerprints, that the subject of that order ought to have an opportunity at least to challenge that at the trial court level? Which is what happened here, but just serendipitously.
Right. I actually don't think you need to, but the reason why is because I think that that there's a minimal level of intrusion here, and even a court order to appear and testify at the grand jury. I mean, if you think about the next step and the person doesn't show up, what happens? What happens if they don't show up when they get a notice to appear for a contempt hearing and they don't show up? What happens is ultimately then you get a piece of paper called a capias and you go take them and put them in a cell. And they could be in the cell for months on end while the grand jury is waiting for them to come in and testify. So they can completely lose their liberty, with the capias. They may be entitled to file a writ of habeas corpus, get a hearing by that route, But to have all of these hearings prior to the police just using the reasonable force necessary seems to me to be unnecessary.
I sort of understand you on sort of creating this whole appellate process, but I mean, here it seemed to have worked fairly efficiently. One said yes, the other said my lawyer's going to file a motion to quash, so we can get essentially some judge to look at this again and conclude whether it was sufficient. That seemed like a reasonable process. Doesn't seem like that would take a lot of time. But you're saying that isn't ordinarily the process, or shouldn't ordinarily be the process?
Well, I think in a compressed time frame like that may work okay. Now here we are 9 months later, and
Understood.
It seems to me we're well beyond the pale of any reasonable process. If we're going to wind up here after 9 or 10 months, why don't we just bring all our grand jury requests up here in the first place?
I'm not disagreeing with you at all, Mr. Zanini. I'm really talking about the interplay right off the bat, where a court is issuing an order for fingerprints and to use force to get them, whether at that point there should be some ability, like a grand jury subpoena for records, you could bring a motion to quash, some ability to at least bring an initial challenge to that order.
Right. I would think the motion to quash is the reasonable route, and it should end there with the Superior Court judge following the court's guidance, for instance, in the Williams case, with all the exhaustive factors they're supposed to review. I also think those factors should be limited to DNA cases, and really the question is, has the grand jury made a reasonable showing that the palm print or the fingerprint is going to aid their investigation and determine whose palm print is on the magazine of the firearm?
Let me ask you, let's assume that this individual was subpoenaed before the grand jury for the purpose of giving palm prints, which I guess he was, except not before the grand jury, but before the BPD, Boston Police Department, correct?
In aid of the grand jury investigation.
Right. He doesn't show. You get a capias. You arrest him. You get prints at the time of the arrest, don't you? I mean, as part of the booking process with regard to that, wouldn't you then be permitted to take prints?
Right. The distinction is that at the booking you don't get what are called major case impressions, and there's there's a difference in the technology.
You don't because you don't
and the
routinely
extent.
do them, or because you can't do them?
Well,
Yeah.
I guess it's not the routine process. I guess physically you could go put their palm print and gather all of that evidence at the moment of arrest. But, it seems to me that's no different than just complying with the initial
Right. Well,
order.
but what you're basically saying is that at some level you can get fingerprints either way, even without this process. Just by a grand jury subpoena, the failure to appear will trigger a process which will end up with the person giving prints.
I suppose we could do it that route and avoid the
Well, I'm not suggesting that's
avoid the motion to quash, and just, if the person doesn't show up, go to the judge and say, give me the capias. And boom. But I don't think we actually take people to the police department and book them on a capias. I think they're brought straight to the courthouse.
Yeah.
I think that's the distinction.
Right.
Yeah, the capias is to bring them to the courthouse, not to the police station for booking. The other point on Levine, Levine created this entire sort of process about weighing all of these different factors in the execution of a search warrant, and it's sort of troubling that there's no other search warrant where you do anything other than assess probable cause. But Levine creates all of these other factors to weigh, and it's a complete outlier in that regard. And again, there was no grand jury process there that was ongoing. It was simply a search warrant, and it was very early on in the technology of DNA. Unless the court has other questions, I'll otherwise leave it to the brief.
Thank you, Counsel.
Thank you.